Good morning. Welcome back to the final day of our hearing in the matter of the application of Washington Gas Light Company for new rates and to revise the terms and conditions of service in its gas tariff in case number 9481. We have a few more witnesses today, beginning with the witness for AOBA. But before we begin the hearing, are there any preliminary matters we need to discuss?
We do have two preliminary matters, Your Honor. First, I handed to the bench, the secretary, and the court reporter, as well as the parties, copies of our responses to commission bench request numbers 3 and 4. That leads into the second preliminary matter, which is I have been presuming that, as in past practice, the commission would identify these and move them into the record on your own motion as commission bench requests. If that is not the case, Washington Gas is happy to label them as, I believe the next one is 46 through 50 as Washington Gas exhibits, but it's up
Yeah,
to
that won't be necessary. At the end of the conclusion today, we'll move these into to the evidence.
Thank you, Your Honor. That's all I have.
Your Honor, I do. First, counsel was under the impression that parties were permitted to do rejoinder to each other in their rebuttal. In other words, I could do rejoinder to OPC or staff to their rebuttal testimony, but not to the company. However, in case I am incorrect, I am going to make a motion that that AOBA be allowed to do brief rejoinder to staff witness Bonikowski, because he filed 3 iterations of his rebuttal testimony. The first on September 25th, slightly revised on September 26th, and substantially revised on the Friday before hearings. So Mr. Oliver would like to address that briefly in rejoinder. That's my first request.
Thank you. Does staff counsel have a position on Ms. Francis's request?
It is highly extraordinary, Your Honor. There is no provision in the procedural schedule for live rejoinder by the parties relative to other parties other than the company. That is the norm, and we do not normally allow it. So on those grounds, we would object to it.
Ms. Francis, what would be the scope of your live rejoinder of Mr. Bonikowski?
Okay. It would be addressing the changes that he made on September 28th to his originally filed rebuttal testimony and what he had to say in regard to those changes.
Okay. In light of the multiple changes in Mr. Bonikowski's testimony, I will allow Ms. Francis brief live rejoinder of the witness.
My second request. On Friday, in the mid-afternoon, staff sent around I believe it's a response to Commissioner O'Donnell or Commissioner Herman, and I'm not sure which, where they asked for what would be the effect of an across-the-board increase on the unitized rates of return. We received that. Later in the afternoon, AOBA requested work papers regarding that chart that Mr. Bonikowski prepared. Over the weekend, we reviewed those work papers, and I can handle it 2 ways. I can object to this response coming into the record, or my second, I guess, request, probably preferable, would be for Mr. Oliver to briefly discuss and comment on whether this document is relevant and why.
Okay, now, we did have a brief discussion with Mr. Oliver and Ms. Francis before the hearing regarding their objection. As I understand it, their objection is not necessarily to the chart itself, it is to staff's position. And that's not going to change regardless of whether the exhibit comes in or not. The exhibit, as Ms. Francis did indicate, was prepared in response to questions by Commissioner O'Donnell. We haven't had a chance to try and put it in the record yet, so in that sense this is premature. But when Mr. Bonikowski comes up on the stand, we were intending to put it in the record and have him give a brief explanation as to what it is at that time.
Your Honor, may I respond?
Yes.
Our objection, staff's position has changed within the course of this case, so I'm not going to respond to that. However, our problem with this chart isn't staff's position. It's the way the calculations were done in this chart. And I believe if Mr. Oliver can address it briefly, we could clarify what this chart shows and what it means and how we interpret it.
Has the witness seen this chart yet?
Yes, and he's looked at the work papers over the weekend.
Okay. I'll allow Mr. Oliver to explain his understanding of what is contained on the chart.
Okay. Thank you, Your Honor.
Mr. Spivak will take this into evidence after your witness sponsors it.
Okay. Thank you, Your Honor.
Any other matters? Okay. Ms. Francis.
AOBA would like to call Mr. Bruce Oliver to the stand.
Do you swear and affirm under the penalty of perjury that the testimony you're about to give in the matter of pending is the whole truth and nothing but the truth?
I do.
Before I mark his testimony, counsel has another statement to make. In Mr. Oliver's testimony, and I have discussed this with counsel for Washington Gas, he makes a statement that he was not provided access to the attorney eyes only designation of staff data request 8-9. And he discusses that staff data request within his surrebuttal testimony and briefly in his direct testimony. That is a correct statement as far as Mr. Oliver goes. However, AOBA and counsel was provided access to that data response labeled attorney's eyes only on June 28th by Mr. Dodge. The error was counsel's, and in counsel's office, it was not communicated to Mr. Oliver. So the error of not sending the designation and extra sensitive password happened in counsel's office, not Mr. Dodge's office. Mr. Dodge did provide that password a second time in September, and that is when Mr. Oliver first saw it. Just as an aside, and I have discussed this with Mr. Dodge going forward, we did not object to the labeling of documents as attorney's eyes only. However, in the future, because we do believe that's a misleading designation, we will work with the company to change that, perhaps something like highly sensitive or extra protection or extra password protection would be more appropriate rather than the current one. But I just wanted the record to be clear that the error that occurred was in counsel's office.
Thank you.
Okay. Mr. Oliver, please state your name and business address for the record.
My name is Bruce Richard Oliver. My business address is 7103 Lake Tree Drive, Fairfax Station, Virginia.
Okay, and Mr. Oliver, on whose behalf are you appearing here today?
I'm appearing on behalf of the Apartment and Office Building Association of Metropolitan Washington.
Do you have a document before you entitled Non-Confidential Direct Testimony of AOBA Witness Bruce R. Oliver, filed on August 21st, 2018, consisting of 70 pages of testimony, 6 exhibits identified as BRO-1 through BRO-6, and 6 attachments identified as attachments A, B, C, D, E, and F, respectively?
I do.
Respectively. Thank you. Your Honor, I ask that the non-confidential direct testimony of Mr. Oliver be marked for identification as AOBA's Exhibit 56.
So marked.
Do you have a document before you entitled Confidential Direct Testimony of AOBA Witness Bruce R. Oliver, filed on August 21st, 2018, consisting of 70 pages of testimony, 6 exhibits identified as Schedule BRO 1 through BRO-6, and 6 attachments identified as AOBA attachments A, B, C, D, E, and F, respectively?
I do.
Your Honor, I ask that the confidential testimony of AOBA be marked as AOBA 56C.
So marked.
As a further aside, just prior to the hearing, counsel discussed with counsel for Washington Gas whether all of the designations in Mr. Oliver's confidential testimony needed to be designated as such. And the response was only the footnote on page 22 needed to be designated as confidential. All the other designations on pages 7, 22, and pages 26 through 27, but for the footnote, do not have to be labeled confidential. Mr. Oliver, do you have a document before you entitled Direct Testimony of AOBA Witness Timothy B. Oliver, filed on August 21st, 2018, consisting of 42 pages of testimony, 7 exhibits identified as Schedules TBO-1 through TBO-7, and 4 attachments identified as attachments A, B, C, D, respectively?
I do.
Do you adopt the direct testimony of Timothy B. Oliver as your own sworn testimony in this proceeding?
I do.
Your Honor, I ask that the direct testimony of Timothy B. Oliver be marked for identification as AOBA Exhibit 57.
So marked.
Mr. Oliver, do you have a document before you entitled Errata to the Direct Testimony of AOBA Witness Bruce R. Oliver and Tim B. Oliver, filed on September 7th, 2018?
Actually, I don't have that in front of me.
Approach the witness, Your Honor.
You may.
Mr. Oliver, is the information provided in that errata true and correct?
It is.
Your Honor, I ask that the errata filed to the direct testimony of Bruce Oliver and Tim Oliver on September 7th be marked as AOBA Exhibit 58.
So marked.
Mr. Oliver, do you have a document before you entitled Supplemental Direct Testimony of AOBA Witness Bruce R. Oliver, filed on August 31st, 2018, consisting of 11 pages of testimony, 5 exhibits identified as Schedules BRO Sup 9 through BRO Sup 13, respectively?
I do.
Your Honor, I ask that the supplemental direct testimony of AOBA Witness Bruce Oliver be marked as AOBA Exhibit 59.
So marked.
Do you have a document before you entitled Supplemental Direct Testimony of AOBA Witness Timothy B. Oliver, filed on August 31st, 2018, consisting of 6 pages of testimony, 2 exhibits identified as Schedules TBO Sup 1 and TBO Sup 2, respectively?
I do.
Do you adopt this supplemental direct testimony of Timothy B. Oliver as your own sworn testimony in this proceeding?
I do.
Your Honor, I ask that the supplemental direct testimony of Timothy B. Oliver be marked for identification as AOBA 60.
So marked.
Mr. Oliver, do you have a document before you entitled Rebuttal Testimony of AOBA Witness Bruce R. Oliver, filed on September 13th, 2018, consisting of 19 pages of testimony and 2 schedules identified as BRO-REB1 and BRO-REB2 respectively, and Attachment A.
I do.
Your Honor, I ask that the rebuttal testimony of AOBA witness Bruce R. Oliver be marked for identification as AOBA Exhibit 61.
So marked.
Mr. Oliver, do you have a document before you entitled Sir Rebuttal Testimony of AOBA Witness Bruce R. Oliver, filed on September 25th, 2018, consisting of 50 pages of testimony and 3 schedules, identified as BRO-SR1, BRO-SR2, and BRO-SR3, respectively, and Attachment A?
I do.
Your Honor, I ask that this Sir Rebuttal testimony of AOBA witness Bruce R. Oliver be marked for identification as AOBA 62.
So marked.
Mr. Oliver, was all of this testimony prepared by you or under your direct supervision or adopted by you?
Yes, it was.
Do you have any changes, corrections, or updates to your testimony?
Not that I'm aware of at this time.
Do you adopt this testimony as your sworn testimony in this proceeding?
I do.
Your Honor, the witness is available for cross-examination. However, I would request that Mr. Oliver begin his live rejoinder first.
Yes.
Okay. Witness Bonikowski's Sir Rebuttal testimony takes an internally inconsistent position.
Excuse me, Your Honor. Shouldn't there be a question?
No.
Yeah, Ms. Francis,
I was under the impression he was just going to do live rejoinder and make a statement.
I don't think that would be appropriate. You have a question of your witness.
Okay. Is Mr. Bonikowski's position in his Sir Rebuttal testimony consistent with his other positions espoused in this proceeding?
I don't believe it is. Witness Bonikowski, relying on Witness Cross for the staff, have rejected the company's cost of service models based on the premise that the results presented in the company's rebuttal cost of service study are different than the results in earlier studies. Neither Witness Bonikowski nor Witness Cross have done any detailed examination of the corrections made, or neither of them have made any attempt to verify whether the corrections made were accurate or appropriate. I've been through those revisions in detail, and I find them to be quite appropriate. In fact, I think I've already stated in my Sir Rebuttal that I believe the company's corrected rebuttal cost of service study is actually more accurate than the one I performed, because the company was able to flow through corrections to the GMA heating class numbers of customers, which then affected therms and revenues, where I wasn't in a position to follow that all the way through and show the effects of all those changes within the cost of service study. So, the GMA class is not the largest class, but with respect to how that flows through, it improves the overall accuracy of the study beyond what I did. As I've already demonstrated in my Sir Rebuttal, the results of the company study and my study are actually very closely in line. But having said that the staff rejects the company's study, Witness Bonikowski then turns around and says, oh, but we're going to rely on some notion of rate of return for the interruptible class alone. we're going to ignore it for all other classes, but because he seems focused on the fact that this class's rate of return deviates from the system average, he wants to make a major adjustment to that class, but not make adjustments to any other class. In fact, there are other classes, particularly the GMA GMA and C&I non-heating classes, that are more deviant from the system average rate of return than the interruptible class, and he doesn't address that. And we find that highly problematic. If you're going to reject the study, then you reject the study and you treat all classes as if you have no knowledge of what rates of return would be. If you're going to accept the study, then you accept it for all classes. But you can't take part of one and part of the other.
Is Mr. Bonikowski's position in his rebuttal testimony wholly dependent on that of any other staff witness?
Absolutely. It relies on the testimony of Witness Cross, who has indicated that he really didn't have time to investigate the cost of service study. And he's, in my assessment...
Excuse me, Your Honor. Staff's going to object at this point. This is very into rejoinder to Mr. Cross's testimony, and the premise of this rejoinder is that it is limited to rejoinder to Mr. Bonikowski.
Sustained.
Okay.
Mr. Oliver, earlier this morning we discussed the fact that staff has provided a response to a bench data request setting forth the unitized rates of return. Have you had a chance to review that exhibit as well as the work papers that staff sent on last Friday?
I have.
And could you please comment on the exhibit and the underlying work papers provided by staff?
As I understand, the purpose of the exhibit was to try to provide the Commission some insight as to how class rates of return would change if you did an across-the-board increase. The problem with Witness Bonikowski's exhibit is that while there's a major change in staff's rate base, almost $100 million is knocked out of the company's rate base, he fails to reflect that change in rate base in a manner that reflects the way the costs that are being excluded from rate base would be allocated in the cost of service study. Rather, he applies a general allocation factor based on all rate base. And that doesn't address the fact that many elements, particularly the major elements of rate base, can be allocated on much different factors. Within the C&I class, for example, if you're allocating an adjustment to services, the C&I heating class, the large C&I heating class, only gets about 13% of it. If it's an allocation of mains costs, they get 21% of it. For one class, that's a huge difference and can make a noticeable difference in the resulting rates of return. It doesn't give you a reasonable indication of class rates of return if you simply apportion the rate base the way everything else was apportioned, when you know that that is not the way it would be done within the cost of service study.
In your opinion, Mr. Oliver, is this a is the Table 1 UROR impact of the across-the-board revenue increase an accurate document on which the Commission should rely to determine the effect of an across-the-board increase on the ultimate rates of return?
No, it is not.
Your Honor, that's all the questions that I have for Mr. Oliver, and he's available for cross-examination.
Mr. Dodge.
Not a question. Mr. Buckley will handle the cross-examination question, but I wanted to put on the record my gratefulness to AOBA counsel for her earlier statement regarding Mr. Oliver's full and timely access to staff data request, the response to staff data request 8-9 dating back to June 28th, 2018. We worked it out easily and graciously, and I just want to make sure that the Commission is aware of the company's gratitude for Ms. Francis's statement. And Mr. Buckley is in charge of cross-examination of this witness. Thank you, Your Honor.
Morning, Mr. Buckley.
Good morning. And it's short. There's no cross for the witness pending something that comes up later from the bench.
Come on, Paul.
Mr. Cleaver.
Your Honor, I don't have any questions for Mr. Oliver. I do have one exhibit I wanted to enter into the record.
You may.
May I approach? Your Honor, I've handed the witness a copy of AOBA's response to OPC Data Request 2-1 to AOBA. The question was propounded on September 26th, and the company timely answered on October 1st. As the response indicates at the bottom, the sponsor was Mr. Bruce Oliver, and I would ask that this be marked as OPC Exhibit, I believe we're on 20.
I believe that's correct.
AOBA will stipulate that exhibit, Your Honor.
All right. We have a discrepancy in the exhibit numbers, whether 19 or 20. Are you still off by one, Mr. Cleaver?
I thought that was... According to my notes, it's 20, Your Honor, but
Okay, well, we'll err on the side of caution and mark this as 20. There may not be a 19. We'll double check that. Any
Thank you.
objection? Seeing none, OPC exhibit number 20 is moved into evidence. Ms. Francis, your testimony of Mr. Oliver, both Mr. Olivers, did you want to move those into evidence?
Yes, I do, Your Honor. I would like to move I want to get the correct numbers. ALBA's exhibits 56 through 62 inclusive into the record.
Thank you. Seeing no objection, AOBA's exhibits 56 through 62, including 56C, are moved into evidence.
Thank you, Your Honor.
Mr. Spivak.
Thank you, Your Honor. Well, I did not have cross for Mr. Oliver, but after the rejoinder, I do have a little bit.
Please proceed.
So, okay, Mr. Oliver, you talked about the results of the interruptible of the class cost of service study, correct?
In generally, class cost of service studies, yeah.
And there were several class cost of service studies presented over the course of this case by the company, were there not?
There were 4 versions of their cost of service studies. The first was their initial filing. There were minor changes in their July 12th filing when they updated to actuals. Then on July 31st, there was a more major change based on a correction that the company felt needed to be made at that time. And then rebuttal testimony after seeing my presentation in direct, the company agreed that there were further corrections that needed to be made to their study, and they implemented those.
Okay. And in the first iteration of the cost of service study, the unitized rate of return for the interruptible class of service, it was something like minus 0.44, is that right?
I don't think that's relevant. I think it's an erroneous result. In fact,
that was the result, however, was it not?
The UROR was about that, yes.
Okay. And in the last iteration of the cost of service studies presented by the company, after all the corrections were done, the unitized rate of return was 0.41. Is that correct?
That's correct, and that leaves the question, were the corrections appropriate?
It does.
And staff has provided no evidence that they're inappropriate, and I've provided evidence that they are.
Okay.
And so is the company.
All right. Now, your observations regarding the chart that Mr. Ponikowski will be presenting, they were based on what staff did or did not do with the rate base, correct?
That's correct.
Right. And you object to staff's position on how the rate base should be addressed in this?
Very definitely.
Okay.
Particularly when you have a major change in rate base, a change of the magnitude of almost 10% of the company's total rate base, and that, if you understand the allocators within the model, would not be allocated in proportion to the total rate base that's in the model, but would be allocated on different allocation factors, some of which are noticeably different.
Right. But given staff's position on the rate base and how it should be addressed in this case, there's not a mathematical error in the chart that staff presents, is there?
I did not find any mathematical errors. That's correct.
Okay, thank you. That's all I have, Your Honor.
Thank you, Ms. Francis. Any redirect? Commissioner Herman.
I just want to be clear. I think what I heard you just say, that while the company's cost service study on which they're developing, they would suggest that the commission develop rates, that in your view that is the most, is a good basis on which to develop rates, I guess, is what I'm saying. Because your rebuttal says it's the best available cost service study in this
That's
proceeding.
correct.
And is that one on which you would support if the commission were to adopt a cost service study, that's the one that should be adopted?
I would.
Okay, thanks very much. That's all.
Commissioner Wood. Thank you. Any follow-up questions based on Commissioner Herman's? The witness is excused.
Thank you.
Ms. Francis, do you have any other witnesses to call?
No, I don't, Your Honor. Mr. Bruce Oliver has adopted Mr. Tim Oliver's testimony.
I think we only have Commission Staff Counsel remaining. Looks like we'll have a change up here.
Staff calls Bayan Ostrander to the stand. Mr. Ostrander, whenever you're ready.
Very good.
Do you swear and affirm under the penalty of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Ms. Garofalo, before we get started with this witness, I understand that Washington Gas has a motion to strike portions of this witness's testimony. Is that correct, Mr. Buckley?
Yes, Your Honor, that's correct.
Do you have anything further to add based on the motion that you filed on Friday?
Only slightly in reply to the staff's reply. I certainly won't reiterate all of the bases for this, but just a couple of small points. The first thing is that the company does agree with one element of the staff's reply. At the second page of that reply, the staff said that the purpose of rebuttal is to respond to rebuttal. We agree. The testimony that's the subject of the motion to strike is not rebuttal at all. It's brand new direct testimony from the witness that could have and should have been put in 5 weeks earlier. The second point would be simply the staff seems to make a point that they somehow have a special status which would allow them to ignore procedural schedules and only treat them as a guideline. I don't believe that that's accurate. I think that the staff has to adhere to those procedural schedules as all parties, and the bench knows that the purpose of procedural schedules is to lead to an administratively efficient hearing. Allowing late filed new adjustments like this is anything but efficient. It's actually inefficient. And the third point is that it is highly prejudicial. There is a number of things that we would say in response to this testimony given adequate time, but yet we don't. And the final point, Your Honor, just in response, again, the staff reply did not take issue with this, but Mr. Ostrander does have a pattern of this type of behavior. I've cited 3 different instances in prior cases where similar maneuvers of late filed evidence has been presented and the commission has admonished him. This would be just another instance of that, and allowing this type of testimony to continue would only encourage further noncompliance with procedural schedules. That's all we have.
Thank you, Mr. Buckley. I saw the footnote that you included with respect to the admonitions in previous cases. I did not look up those cases, but I'll take your word for that. Ms. Garofalo, you filed a reply yesterday, I believe.
I did. If I can just make four-ish points. WGL has a burden of proof in this matter, and the company cannot meet this burden by striking parts of other parties' testimony merely because an issue is developed after direct testimony has been filed. By making its motion to strike, WGL is asking the Commission to place form over substance, basically employing the procedural schedule, which is intended primarily to meet the statutory time frame for consideration of a rate filing, as a means of removing evidence from the Commission's consideration when arriving at a decision. The company has in no way been prejudiced. The staff witness indicated on direct that he might make this adjustment. WGL responded to the adjustment in written remarks, written rejoinder, responded again through its motion, and has the opportunity to cross-examine Mr. Ostrander on this issue. Finally, staff does have a statutory burden to pursue issues that might be relevant to your decision in this case, and it's staff's duty to complete the record, and staff's witness has shown integrity by not leaping to conclusions with only 3 days to consider this adjustment, but by taking time to consider this adjustment in the manner in which it applies to all adjustments in this case. Given the short time that most parties have for preparing their case and the virtually unlimited time that a company has to prepare a case, we oppose the motion and we ask that you accept Mr. Ostrander's testimony in full.
Thank you. Ms. Garofalo, recognizing that there wasn't a lot of time for Mr. Ostrander to respond, why did staff counsel not file a late motion to include supplemental direct testimony in this case, rather than having Mr. Ostrander respond for the first time in rebuttal?
Well, I guess we could have done that. I don't have an actual reason. It really did not come up. This is a case, it's quite complicated from the accounting standpoint. There are at least 2 accounting witnesses, and there are over 50 adjustments, each of which has multiple parts, and so we did not do that.
Mr. Buckley, witness Termini, did he not respond in written rejoinder in response to Mr. Ostrander's rebuttal testimony?
Your Honor, that's correct. We put a cursory response in. I could proffer that there are some additional elements that we could provide in response to this, but actually one factual correction from Ms. Garofalo. There was that 3-day gap where the witness had those data requests that he referenced. But the underlying facts of the amounts that were at issue, they actually were even placed in Mr. Ostrander's testimony. They were available a month earlier than that. So this really is an example of the staff sleeping on its rights, not asking questions earlier, not bringing things in a timely fashion. And it does prejudice us. There are facts that we would bring to the Commission's attention given more leisurely basis, such as these very same software costs were considered by the Virginia Commission with the same apportionment between capital and expense, and those were recognized without adjustment. We would bring in the accounting standards that's at issue that the company has followed, and there's no contention that we haven't followed those. We don't have any of that material in the record, and the like. So we did provide a very cursory response, but it nonetheless was the best that we could do under those very short time frames. And we are prejudiced in that regard.
Thank you. The procedural schedule is important, and parties need to abide by this schedule. It almost seems like we have too many rounds of direct reply, surrebuttal, amended surrebuttal, and on and on. At the same time, I do not want to put form over substance, and would allow for some exceptions where they're warranted. I find that WGL did have an opportunity to write some written rejoinder on this case, and you'll have the opportunity to cross-examine Mr. Ostrander in just a few moments. This has been a messy case, I think, from the beginning, with a number of supplemental rebuttal testimonies being filed, in addition to multiple class costs of service before us being revised up until the eve of hearing. That being said, there is some prejudice to WGL, notwithstanding the fact that I'm going to deny the motion. If the company wishes to recall Mr. Tiramini at the conclusion of staff's witnesses, I will permit that in order to provide a response to BCO number 27 on that topic only, if you choose to recall that witness.
Thank you, Your Honor.
Okay. Ms. Garofalo.
Good morning, Mr. Ostrander.
Good morning.
Mr. Ostrander, do you have with you 3 documents? One entitled Direct Testimony and Exhibits of Bayan C. Ostrander, consisting of, I believe it's 73 pages of text, an attachment, and multiple exhibits. 61 pages of text.
Yes, that's my direct testimony. I have both the confidential and public version.
So you have so you have 2 direct testimonies. One is the public version, one is confidential.
Correct.
Your Honor, I'd ask that the direct testimony of Mr. Ostrander be marked as Staff Exhibit 13.
So marked.
And that his confidential version be marked as Staff Exhibit 13C.
So marked.
And Mr. Ostrander, do you have with you a second document entitled Surrebuttal Testimony and Exhibits of Bayan C. Ostrander? And I believe this one does have 73 pages of text, multiple exhibits, and also a series of data requests that were relied on in your testimony.
That is correct. And I might also add the direct testimony, both the public and confidential version, also had exhibits and data requests attached.
Thank you. So were each of these 3 documents prepared by you or under your direct supervision?
Yes.
Ms. Garofalo, what are we marking as the
I
surrebuttal?
apologize. Surrebuttal, Staff Exhibit 14. There's no confidential version.
Thank you. I'd just like to note the surrebuttal testimony is longer than the witness's direct testimony. In a perfect world, as we proceed with the briefing schedule, we're supposed to narrow with the issues, and the surrebuttals are supposed to get shorter, not longer.
It is a little longer.
Ms. Garofalo, please continue.
Do you have any changes or corrections you would like to make to any of these documents at this time?
Yes, I have several corrections to my direct testimony. First of all, on page 28, footnote 29, strike the words and the word long, but leave the hyphen there. So the revised language reads short-term incentives and removes the reference to long-term incentives. Turning to page 30, line 9. This edit is for the same exact reason. Remove the reference or the words and long, and again leave the hyphen. So the revised language reads short-term incentives and removes the reference to long-term incentives. Finally, page 44, line 1. About 5 words in there, strike the word gas and replace it with electric. That completes the changes to my direct. I have one change to my SIR rebuttal. That's at page 11. Footnote 20. Beginning with that second sentence that starts with purchase gas of $95,883,278. Strike the words purchased gas and replace that with net operations and gas costs. And that completes the revisions to my testimony.
Mr. Ostrander, with these changes, if you were asked the same questions contained in your direct and SIR rebuttal testimony today, would your answers be the same?
Yes.
Do you adopt these documents as your sworn testimony in this proceeding?
Yes.
Your Honor, I would ask that Staff Exhibits 13, 13C, and 14 be admitted into evidence subject to cross-examination.
Seeing no objections, Staff Exhibits 13, 13C, and 14 are moved into evidence.
The witness is available for cross-examination.
Mr. Buckley.
Thank you, Your Honor. Good morning, Mr. Ostrander.
Good morning.
First of all, I'd like to offer my condolences on the recent loss in your family. I don't think we'll be very long here this morning, and you'll be winging your way back very shortly.
Okay, thank you.
Let's start with your direct testimony, please. If I can get you to turn, please, to pages 7 and 8.
Okay.
Do you have that, sir?
Yes.
So there you discuss, do you not, rate-making concepts in Maryland, specifically historic average test year, correct?
Yes.
There are a number of other principles that guide commissions in their determinations of just and reasonable rates. Would you agree?
Yes.
For example, are you familiar with what is generally known as the regulatory compact, which is the principle that the utility is obligated to provide safe and reliable service, but in return they're entitled to the recovery of reasonable expenses, plus an opportunity to earn a fair return on shareholder contributed capital?
Yes, I don't have a problem with that.
And another one of those principles that helps guide the commission that you see quite often in orders is that the commission views its job as balancing the interests of customers and shareholders. Are you familiar with that?
Yes, I agree with that.
I'd like you to turn, please, to page 10 of your testimony, of your direct testimony.
Yes.
In the bottom part of that page there, and again, you're talking about the future test year, correct? The forecasted test year?
Yes.
In that paragraph, beginning at lines 14 down through 24, you describe a number of criticisms that you have regarding forecasted test period, which include at line 18, a greater burden of proof, line 20, that it's very difficult for regulators to determine what's a reasonable forecasted amount, and at line 21, that guesses are involved by the Commission in making a forecasted test year. Do you see those?
I see those.
Do you also recognize, Mr. Ostrander, that many other state commissions utilize forecasted test years?
I know other states do, and I've worked in those states.
And do you have a rough idea of how many of the 51 jurisdictions utilize forecasted test years?
I don't know, but I know some of those jurisdictions allow either a forecasted or an actual. So there are some that allow both.
Would it surprise you that as many as 21 and perhaps even greater use forecasted test years in the setting of rates?
Not necessarily.
Are you familiar, Mr. Ostrander, with the National Regulatory Research Institute, which is the research arm of the NARUC?
I'm familiar with that agency.
And they routinely produce papers of interest regarding the regulation of public utilities, including on rate-making topics like forecasted test years, correct?
I believe that's correct.
And are you familiar that they have actually issued a couple of papers regarding forecasted test years?
I think I saw one many years ago. I haven't seen a recent one.
Your Honor, permission to approach?
You may. Mr. Ostrander, I've handed you two documents. I'd like you to direct your attention first to the response to Washington Gas Light Company Data Request 2-7. You see that, sir?
Yes.
It's a two-page document which requests a list of your cases for the past 10 years, and the second page provides an attachment which has a listing of those cases for the 10-year period, correct?
Correct.
And do you believe that the information on this document remains correct as of today?
Yes, these are the rate cases. There's other services I perform that are non-rate cases that are excluded from here.
Your Honor, I would ask that this document and the accompanying exhibit be marked for identification purposes as WGL, and I believe we are up to 46.
So marked.
And I would ask that it be received into evidence.
Seeing no objection, WGL Exhibit 46 is moved into evidence.
Mr. Ostrander, I'd like to draw your attention for a couple of short questions to the NRRI document that I handed you. And Your Honor, I would ask that this be marked for identification purposes as WGL Exhibit 47.
So marked.
Mr. Ostrander, is this one of the NRRI papers that you had in mind when you said that you believe that they have issued papers regarding forecasted test years?
This particular paper is dated October 2013. I'm not sure if I've reviewed this one or not.
Okay, let's take a quick look through it if you would, please. Maybe it'll refresh your recollection. If you turn, please, to page 7.
Okay.
At the top of that page, sir, do you see that this involves a survey that NRRI sent out to 21 state utility commissions that allow FTYs, which is forecasted test years?
Yes.
So there's a confirmation, at least from NRRI in 2013, that there were 21 commissions, correct?
sent out survey questions to 21 state utility commissions that allow FTYs.
So that would indicate that, at least as far as NRRI, the research arm of NARUC, is concerned, 21 state commissions, as of 5 years ago, were employing forecasted test years, correct?
That would appear to be correct.
Let's turn back, please, to the executive summary, which is at page Roman numeral small 4. You have that, sir?
Yes.
If you look 4 paragraphs down, I just want to direct your attention to the first 2 sentences. And the first sentence indicates that one general finding was that...
Your Honor, I'm going to object. This document, the witness said that he doesn't recall ever seeing it before. It was authored by Ken Costello, who's not here to testify. I'm aware that in administrative proceedings, the rules of evidence are, of course, relaxed. That said, there's been no foundation laid for this document, and this is an executive summary drafted by the author or authors of the report who aren't here to testify. It's being read into the record as though it's fact. And while the company has yet to attempt to introduce this into evidence at this point in time, I would object to reading from a report where no foundation has been laid to impeach this witness's testimony.
Your Honor, if I may?
Yes.
This is impeachment. We went through Mr. Ostrander's criticisms of the forecasted test year, and this paper does go towards and address the criticisms that he levies and how other states have resolved those and actually don't have problems with that. And
If I may be heard in response to what Mr. Buckley said, Your Honor. Thank you. Your Honor, the reason I didn't object to the first questions based on this report are that it was based on facts. You know, this many states have these kinds of laws. This is one person's editorializing on his opinion as to, you know, what this data may show or the value or the wisdom of alternative rate-making paradigms. And I don't think that's appropriate to read into the record when there's been no foundation laid with this witness for that in this case.
No, I tend to agree with you, Mr. Cleaver. We've marked the exhibit. I suspect you'll object if WGL attempts to move it into evidence. Mr. Buckley, I don't want you to read this piece into the record. If you could attempt to reframe your question. Ideally without using this marked exhibit. I recognize the challenge it poses, but People's Counsel raises a good point. We have no foundation for this NRRI report.
So I'm only struggling, Your Honor. I would seek guidance from the bench. NRRI is an independent entity that is a research arm of NARUC. It's not a utility or a consumer advocate entity. Their documents are routinely admitted into evidence before this commission, including recently in our merger case and our expansion cases. The purpose of this is to highlight those very same criticisms that Mr. Ostrander has levied have been discussed in this document, and the various commissions describe that they have understood those challenges and overcome them. I'm happy to leave this to briefing, but it would be laborious for us to go through page by page by page to get to that point.
The witness has acknowledged that a number of states that he is familiar with is accepting of the practice of using a forward test year. I think he could probe his expertise and knowledge of those commissions' use of what do we call it, an FTY, without relying on the conclusions of NRI in this case.
Very well, Your Honor. Mr. Ostrander, you have indicated earlier that you have testified in a couple of jurisdictions even that have employed a forecasted test year, correct?
That's correct.
Would that include the state of Kentucky?
Yes.
And are you familiar with prior testimony that you've delivered to Kentucky where you opposed the use of a forecasted test year, but that the Kentucky Public Service Commission rejected your challenge and actually employed a forecasted test year?
I believe that's correct.
I'd like to turn to your sir rebuttal, please. Specifically, Mr. Ostrander, pages 14 through 18.
Okay.
This testimony responds to and justifies your exclusion of roughly $1.2 million of marketing expenses. Is that correct?
Yes. Relates to exclusion of institutional and promotional, but allows informational to be included in the case.
So help me, Mr. Ostrander. So you've, on one hand, recommended that the Commission reject the company's marketing expenses, which, as Ms. Johnson has testified, is designed to attract incremental new load, correct?
No, I haven't recommended on a wholesale basis that the Commission reject all marketing expenses. What I proposed is consistent with COMAR, which basically says the burden is on the company to prove that both institutional and promotional advertising is in the public interest and provides a direct benefit to ratepayers. And to this point in the proceeding, Washington Gas has not provided any documentation to show that there's a direct benefit to customers.
Mr. Ostrander, I recognize you were not in the room when Ms. Johnson testified, but were you watching over the internet, or have you had an opportunity to either review the YouTube plays of her testimony?
I did watch that.
So did you see, not asking whether you agree, did you see Ms. Johnson's testimony that the two FERC accounts in dispute here in this case relate directly to marketing expenses that the Commission has allowed in prior proceedings? Did you see her say that?
I'm not sure, but I am aware that the Commission has allowed those in prior cases, although I'm not sure that they have been contested in prior cases.
So actually, Mr. Ostrander, in a prior Washington Gas case, 9267, do you recall challenging the marketing expenses of Washington Gas?
I don't recall.
Okay. Would you accept, subject to check, that you challenged the expenses and the Commission's rejected that challenge? Subject to check. Okay. So let's accept for a second now, you've got the disallowance of the $1.2 million of marketing expenses, and I'll ask you to further assume that they are geared towards acquiring incremental load, customers to switch to natural gas, for example. Can you point to me in your testimony where you have taken out the revenues associated with the new load that's been obtained during the test year? So on one hand, you're rejecting the company's recovery of expenses, but can you show me on the other hand where you've taken the revenues that it's produced and pulled it out to be even-handed?
I don't see how you can necessarily draw a correlation, and I haven't seen that the company has presented a strong correlation that advertising can lead to a very specific revenue base from a very specific customer base.
So it's your testimony that advertising expenses don't produce new business?
They're intended to, but they don't always.
And did you see Ms. Johnson's testimony, which is unchallenged, that the company's new business calculations are demonstrating that $20 million on an annual basis for the last 3 fiscal years have been produced in net positive benefits to customers?
I've never seen any detailed analysis or study supporting that in this record.
Let's turn, please, to your adjustment number 10. That would be in your survey rebuttal between pages 45 and 46.
Okay.
You recognize, sir, that the company's response to an increase in leaks is one of the more notable issues that's been presented in this case in front of the commission, both in terms of the amount of testimony as well as the dollars that are at stake, correct?
Yes.
So there are a couple of different elements to this. First of all, would you agree that you have recommended the rejection of company's adjustment number 27, which was the $4.7 million of incremental expenses that Mr. Tornimi's testimony supported?
Yes, I removed those because the company has indicated in various data requests that those are all projected costs, and so they're not known and measurable.
You also have additional disallowance, do you not, Mr. Ostrander, of roughly $900,000 related to, I believe, and you called it a non-reoccurring leak expense. This relates to the company's mutual aid that they received during the test year, during the test period?
Yes, the company's response to a data request referred that to as a one-time or non-recurring accrual, and there was no indication or follow-up from the company that that was a representative of subsequent actual expenses.
Finally, Mr. Ostrander, there is an issue in this case that's also related to the leak response and management, and that relates to the amount of overtime as well as the number of company employees that have been utilized both during the test period and a period between the test period and the evidentiary hearing, as well as forecasted, correct?
Correct.
Now, did you read Witness Gibson's rejoinder to your overtime testimony?
Yes, I did.
Now, I'm only asking for if you agree with the calculation, not a speech on whether you agree with the rationales. But Mr. Gibson calculated that your ultimate recommendation on the company's overtime adjustment amounted to a reduction of 28% of that overtime. Is that right? Do you agree with that?
I believe that's correct.
Now,
Well, I have to preface that.
we'll say subject to check.
Well, it's
So-
not completely accurate in the form that he stated it.
We'll leave it there. So you indicated earlier that you watched the replay of company witness Johnson's testimony. Did you also have an opportunity to either view live or in replay staff witness Clemenson's testimony?
I did not.
Have you read staff witness Clemenson's testimony?
Yes.
And is it your do you agree with that your recollection would be that staff witness Clemenson's testimony included a detailed chart of the company's leak history in recent years, and that it showed a clear trend in the increase in leaks that have been reported on the company's system?
Yes, his testimony shows that.
And I would ask you to accept, subject to check, that witness Clemenson not only agreed that there was a clear trend in those increases, but that based upon existing safety regulations that the company would be required to take action based upon that information. Would you accept that, subject to check?
I believe he did say that, and he also agreed with my adjustment to remove the $4.7 million of leak management expense.
And he also stated that he doesn't do COS and he was relying upon you for that. Would you also accept that, subject to check? That was his live testimony, sir.
Your Honor, the witness has answered the question.
We'll move on. So, Mr. Ostrander, if I can get you to please to turn to page 46 of your this is again your supplemental testimony?
Okay.
Sir, rebuttal, excuse me. At lines 3 through 4 there, sir, you talk about the company not having provided any actual cost to date to replace the estimated costs.
Correct.
And again, I understand you're at a bit of a handicap that you haven't been present during the hearings, but did you either watch or see the testimony from Mr. Tornimi where he provided testimony that the company has incurred $3 million of response, leak response and odor response costs on an actual basis through August?
I believe I did see that, and I also saw that in his rejoinder testimony, but I don't agree with that characterization because although he states the company has incurred actual costs of $3 million between March and August of 2018, I issued staff data request 13-14 asking for the company to identify actual versus projected cost and provide supporting documentation. And the company said all of those costs are projected. None of them are actual. And the most important thing is that data request was dated July 18th, 2018. So we have a clear contradiction from a data request response and from what Mr. Tornimi has stated. So I can't make a conclusion that I can rely on Mr. Tornimi's statement because I have a specific data request through nearly the end of July that says no actual costs have been incurred. Now, if between July 18th and somewhere in August that entire $3 million was incurred, I guess that's a possibility. But then there's another data request, 13-18, again, that says, just to clarify, that all of these costs in the leak management adjustment were projected, and I asked for copies of invoices and supporting documentation for all actual costs. And again, the company stated in the response to 13-18 that all the costs were projected, no actual invoices or customer vendor information is available. And again, that data request was dated mid-July also.
And Mr. Ostrander, both those data requests referred to company's adjustment number 27, correct?
Yes.
If you recall.
For leak management.
And company 27 was a fully projected adjustment, as you call, correct?
That's what the company stated.
So I'll ask you as a hypothetical. Given Mr. Clemenson's testimony and the company's unambiguous testimony here today, here in this hearings by Mr. Tornimi, that there has been $3 million of actual expense incurred by the company to respond to odor and leaks, would you support the inclusion of that $3 million based on Mr. Clemenson's statement that those actions are reasonable?
No, I can't because I haven't seen any supporting documentation, and I've clearly got two data requests that are contrary to that statement and that in fact say up through July 18th, 2018 that no actual costs had been incurred.
Permission to approach, Your Honor?
You may. Mr. Ostrander, I've handed you a document which includes a number of different responses to Washington Gas data requests. Can you take just a few moments to refresh your recollection on those and review the accuracy of them? And I would highlight for you a little more than halfway through in response to Washington Gas data request 2-12, the sponsor of the response is actually staff counsel and not you. So if you just take a moment just to refresh your recollection, please.
Okay. Okay.
Mr. Ostrander, with the exception of the response to WGL 2-12, were these responses prepared by you?
Yes.
And do the information in them remain accurate today?
Yes.
Your Honor, I would ask that these documents be marked individually to make the briefing easier as Washington Gas Exhibit, WGL Exhibit 48 through 53.
So marked as Exhibits 48 through 53.
And presuming that the staff will not object to the admission of a document that they prepared by their own counsel's office, Washington Gas would ask that these exhibits all be received into evidence.
WGL Exhibits 48 through 53 are moved into evidence. And while we're on that point, what did you want to do with Exhibit number 47, Mr. Buckley?
Your Honor, we asked that it had been marked, and you had already ruled that you believed it was inappropriate for having it admitted to evidence. Therefore, we didn't offer it. But I would ask that it be received so we can have a formal ruling on the record.
Yeah, I did not say that it would
I'm
be
sorry.
inappropriate. I surmise that People's Counsel would object to such a motion.
Well, I would therefore move, as well as the rest of the packages, that it all be received into evidence.
Is there any objection?
As far as People's Counsel, Your Honor, no objection to 48 through 53. I would object to WGL Exhibit 47 for the reasons discussed previously, that it's a report that contains opinion by an author that's not here without a proper foundation.
Thank you. You raised good points, Mr. Cleaver. However, I am going to allow WGL 47 to be moved into evidence. It was used to elicit some facts which the witness did not dispute. So for those purposes, WGL 47 is moved into evidence.
And we previously have moved into evidence 46 and then 48 through 53 in evidence as well, Your Honor.
That's correct.
Thank you, Your Honor. No further cross for the witness.
Thank you. Ms. Francis.
No questions, Your Honor.
Mr. Cleaver.
No questions, Your Honor.
No redirect.
This is moving quickly. Commissioner Herman.
Just briefly, good morning, Mr. Ostrander.
Good morning.
I believe you have disallowed the adjustment for labor that was taken out during the merger. Is that correct? There's an adjustment that takes out a certain amount of labor that was charged to the merger, and the company proposed to put that labor back in. Is that correct? The cost of that labor?
I propose to remove a piece of that. I only propose to remove the short-term incentive portion of that labor, and I think witness Efron proposed to remove the entire portion of that payroll, which included the short-term incentive and regular payroll.
So you just took out the short-term incentive portion of that labor?
Yes, because it's non-recurring. The company even calls it discretionary. It's related to a merger, a one-time event.
Okay. That's all I had. Thank you very much.
Just a point of clarification, Mr. Ostrander. You make a number of adjustments, perhaps dozens of downward adjustments in your testimony. Did you make any adjustments upward in favor of the company?
Yes, I did.
Okay. Where was that, if you could point me to?
Okay. I believe I was accused of WGL for only making adjustments one direction, and in fact, all of my adjustments I made consistently. So regardless of whether the adjustment went up or down, if it had involved removing post-test period amounts that were not known and measurable, I removed them regardless which direction they went. I know on the purchase gas, the revenue and forecasted revenue and purchase gas adjustment, Mr. Tornimi accused me of removing that because it was favorable to staff's position and that it decreased the revenue requirement. But in fact, that is absolutely wrong, and I think Mr. Tornimi admitted that in his rejoinder, and admits that that adjustment that I made actually increases the revenue requirement to the company's favor. So that was a net adjustment of about $4 million that increased the company's revenue requirement. The company had three components to that adjustment. Part of it was forecasting revenues partially within the test period for the period through December 18, which is outside the test period, and then another forecasted period through December 2019. And my original direct said I was going to remove only the post-test period amounts to make consistent with the rest of my test period adjustments, of removing adjustments that aren't known and measurable. And then the company's rebuttal said the in-period piece was also forecasted, so I removed it also. So I removed that piece. Another piece is the long-term incentives. The company proposed to remove 50% of its long-term incentives. And again, they went out to approximately December 2019 and removed long-term incentives. And I actually, again, took the post-test period amount of that and reversed it. So I think that, again, actually increased the revenue requirement in the company's favor, I believe some $500,000.
So above 50%.
Yes.
Okay.
So those are just two examples.
Okay, thank you, Mr. Ostrander. I was just curious. Commissioner Linton, any questions for the witness? No. Do the parties have any follow-up based on our questioning?
No, Your Honor.
No. Thank you. The witness is excused.
Thank you.
Ms. Garofalo, please call your next witness, or Mr. Spivak.
Yes, so staff would call Matthew Bonikowski.
As Mr. Bonikowski gets comfortable, why don't we take a break at this point? 10 minutes, 11:35, we'll reconvene. No, thanks for the reminder. Mr. Spivak, whenever you're ready.
Thank you, Your Honor. Good morning, Mr. Bonikowski.
Morning.
Do you have in front of you a document captioned in case number 9481, that's this case, entitled Direct Testimony and Exhibits of Matthew J. Bonikowski, on behalf of the staff of the Public Service Commission of Maryland, and dated August 21st, 2018?
Yes, I do.
Does the document consist of 11 pages of question and answer testimony, and I believe it's 3 exhibits?
It does.
Did you prepare this document, or was it prepared under your direct supervision?
It was.
Do you have any additions, deletions, or other corrections you would like to make at this time?
No, I do not.
If the questions were asked of you today as they were asked in this document, would your answers be the same?
Yes, they would.
And do you adopt this document as part of your sworn testimony?
I do.
Your Honor, staff requests that Mr. Bonikowski's direct testimony and exhibits be marked as Staff Exhibit 15, please.
So marked.
Do you also have in front of you a document entitled Rebuttal Testimony of Matthew J. Bonikowski on behalf of the staff of the Public Service Commission of Maryland, and dated September 13th, 2018?
Yes, I do.
And does that document consist of 4 pages of question and answer testimony?
Yep.
Did you prepare this document, or was it prepared under your direct supervision?
I did.
Do you have any additions, deletions, or other corrections you would like to make at this time?
No, I do not.
If the questions were asked of you today as they were asked in this document, would your answers be the same?
Yes, they would.
Do you adopt this document as part of your sworn testimony in this proceeding?
I do.
Your Honor, staff requests that Mr. Bonikowski's rebuttal testimony be marked as Staff Exhibit 16.
So marked.
And do you have in front of you a document captioned in this case titled Corrected Sir Rebuttal Testimony and Exhibits of Matthew J. Bonikowski on behalf of the staff of the Public Service Commission of Maryland, and dated September 25th, 2018?
Yes, I do.
Does the document consist of 7 pages of question and answer testimony and 2 exhibits?
It does.
Do you have any additions, deletions, or other corrections you would like to make at this time?
No, I do not.
If the questions were asked of you today as they are asked in this document, would your answers be the same?
Yes, they would.
And do you adopt this document as part of your sworn testimony in this proceeding?
Yes, I do.
Finally, do you have in front of you a document with a header description and a table on it labeled Table Number 1, UROR Impact of an Across-the-Board Revenue Increase?
Yes, I do.
Can you tell us why you prepared this and what it represents, please?
So this document was prepared in response to a line of questioning I heard from Commissioner O'Donnell, I believe during witness crosses, while he was on the stand, questioning what the magnitude of the impact of an across-the-board revenue distribution would be if the Commission were to use the class cost of service study presented by the company in Witness Gibson's rebuttal testimony. And this was an attempt just to give, to provide a rough example, an illustrative example of what those rate impacts would be under staff's proposed across-the-board revenue increase.
Do you have any other comments or things that you would like the Commission to know about this document?
I would note that under this document, we're apportioning the revenue increase as across the board. There is no special increase made to any individual class. For example, I don't have any adders for the interruptible class. It is a true across-the-board revenue increase.
Your Honor, staff requests that the table that Mr. Bonikowski has just been introduced be marked as Staff Exhibit 18.
So marked.
Staff further moves Staff Exhibits 15, 16, 17, and 18 into the record.
Seeing no objection, those exhibits are moved into evidence.
And the witness is available for cross-examination.
Mr. Kane.
No cross-examination.
Ms. Francis.
Your Honor, I have some data responses I want to enter into the record by stipulation with staff. I
Yes.
believe the witness has a copy. I would like to mark staff data response to AOBA data request 1-2 as AOBA 63.
So marked.
I would like to mark staff response to AOBA data request 1-3 as AOBA 64.
So marked.
I'd like to mark staff response to AOBA data request 1-4 as AOBA 65.
So marked.
I'd like to mark staff response to AOBA data request 1-5 as AOBA 66.
So marked.
I would like to mark staff response to AOBA data request 1-6 as AOBA 67.
So marked.
I would like to mark staff response to AOBA data request number 1-8 as AOBA 68.
So marked.
I would like to mark staff response to AOBA data request 1-9 as AOBA 69.
So marked.
I would like to mark staff response to AOBA data request 1-16 as AOBA 70.
So marked.
And I would like to move AOBA's exhibits 63 through 70 into evidence.
Seeing no objection, AOBA exhibits 63 through 70 are moved into evidence.
That's all I have, Your Honor.
Thank you. Mr. Cleaver.
No questions, Your Honor.
No redirect. Commissioner Herman.
So, I'd like to ask you about the customer charge.
Okay.
It's your position that for purposes of gradualism, it should go to $11 from $10.20 as opposed to $11.75 as proposed by the company,
Yes, that's correct.
right? And would you agree that by moving it into the fixed charge, the customer still pays, it's just not in the volumetric portion, is that right?
That's correct. The total revenue, in theory, should be the same whether it's collected through a fixed charge or through a volumetric charge.
Right. And is it, you also agree that customers that, with cost causation, that if all customers are causing the cost to be incurred, we should get as close as we can to having those customers pay for that cost, right?
Yes.
Right. And in your view, are you concerned with an increase causing customers not to be interested in conservation? Will that affect their decision-making on conservation in your view?
So there's always a consideration that shifting from a volumetric to a fixed charge would have that impact. I think that the overriding concern in staff's view is ensuring equity in how costs are recovered. So right now, there's a pretty consistent record in WGL rate cases that fixed costs are not being recovered through the fixed charge. And our position is that we would like to move towards shifting costs into the category under which they're incurred. I think that would be the most appropriate and reflective of how gas service is actually being provided and what the cost structure is. I still firmly believe that customers would be interested in pursuing energy efficiency and energy savings measures. They still have the ability to affect a majority of their bill, I believe, through those measures because the volumetric charge is still significant.
Thank you very much. That's all I had.
Thank you, Commissioner Herman. Mr. Bonikowski, thank you for being here today. I appreciate you mentioning the exchange between Witness Cross and myself. And his response to me, in part, or to the bench in part, was included a promise to buy you lunch, and I would highly recommend you take him up on that. Don't forget. I wanted to kind of see about, and it's a follow-up to Commissioner Herman's question, the impact on the average residential heating and cooling customer. So if I understand it, as if your recommendation is completely adopted, the proposed increase would be 55 cents. Is that right, per month for the variable piece? I'm looking at page 11, table 6. Top line is RHC, and it says current
Sorry,
average bill.
I'm sorry, which testimony are you referring to?
Sorry. Direct, you're direct.
Okay, so I would note that the Sir rebuttal testimony actually has the
Change
latest
that.
proposal. Yeah,
So-
our recommendation did significantly change between
Okay,
the
can you
direct
take
and
me
the
to
Sir
that?
rebuttal.
Give me a second to get there.
Sure. And that would be the corrected Sir rebuttal testimony.
There's so many pieces of paper, it's hard to keep up with it all. Could you kindly show me which page so I can get there?
So on the corrected Sir rebuttal testimony, Exhibit 1S on page 8 shows the bill impacts, average bill impacts for each customer class, along with the percentage impact for staff's recommendation.
Okay, so it's not 55, hang on.
So
Let me back you up a page to table 4. Is that easier for me to read?
that works as well.
Yeah,
Yep.
the proposed increase, so it's not 55 cents, it's $3.17 a month. Is
That's
that right?
correct. Yep.
And your fixed charge will stay fixed charge recommendation will stay the same.
I continue to recommend an 8% increase to the fixed charge.
Okay, well, my question was formulated on me thinking, going into it, that you were recommending a 55-cent increase on the variable and an 80-cent increase on the, or whatever it was, on the fixed, and so that was confusing me a little bit. Now this makes a little more sense to me, so I withdraw my question. Thank you.
Any additional questions based on Commissioner O'Donnell and Herman's questions? No. Thank you. The witness is excused.
Thank you, Your Honor.
Mr. Spivak, do you have any additional witnesses?
We do not, Your Honor.
For the company, do you wish to recall Mr. Torini for the purposes we discussed earlier?
The company will not unless it is the bench's preference to have him on the stand again.
Do commissioners have a request? Seeing none. Are there any other matters that the parties have for the commission before we conclude? Mr. Cleaver.
Yes, thank you, Your Honor. Your Honor, at the outset of the hearings, we discussed OPC's motion for a partial summary judgment, which we submitted via letter to the Commission. At this point, we would renew that request based on the testimony that we've heard. That hasn't changed our assessment of where things stand with respect to rate design in this case. So we would ask for a ruling from the Commission so that we can know as we go into the briefs that any revenue increase authorized in the case will be across the board. We would reserve the right to argue on brief the appropriate percentage increase to the customer charge.
Thank you, Mr. Cleaver. People's Counsel's motion for summary judgment, partial summary judgment, is denied in this matter, even though it was confusing that we had 4 or 8 different class costs of service, depending on how you count them. It did not make it easy for the parties to litigate in this proceeding. That being said, the company never actually withdrew any of its cost of service, so we did have a cost of service study that is active. We have multiple cost of service studies in this case. Material issues of fact were not present here, so I do not see it within our scope to grant your motion in this case. You do reserve the right, however, to fully brief this when you're preparing your filing.
Thank you, Your Honor.
We do have a number of bench requests that I'd just like to move into evidence. We took care of the one sponsored by witness Bonikowski just a moment ago, but we have a few others. I believe they're all marked. They are not all marked, so let me just mark them. There was the bench request of Commissioner Herman to James Wagner. I'll mark that as bench request number 1. Washington Gas Light provided what I'm characterizing as bench request number 2, containing 3 pages of a spreadsheet for energy taxes for Montgomery, Prince George's, and St. Mary's counties for fuel and energy taxes. Item in response to Commissioner Linton from the Washington Gas Light Company regarding billing accuracy data, consisting of 1 page with a chart and accompanying data. Then we have what's labeled as response to commission bench request number 4 from Washington Gas Light Company, providing a table entitled Maryland Stride Rate Base Calculation from January 2014 through September 2018. Seeing no objection, we'll move those.
Mr. Chairman,
into
just
evidence.
for clarification, items number 2 and number 4 on that item were at my request, in case there was a question about that.
Yes, thank you, Commissioner O'Donnell.
Mr. Chairman, if I may, I had originally marked in my personal marking as our response to CBR number 1, our response to OPC data request number 1-99. I'm happy to mark that as CBR number 5.
Oh, 199, you're right. Let's mark that as number 5. I don't have that in front of me, but I do recall that one. Thank you.
Your Honor.
Your Honor, just to clarify, the one that was the Montgomery County, Prince George's County energy taxes, what exhibit number was that?
Commission bench request number 2.
Thank you.
It was also, I think, attachment A to OPC 9-3.
Your Honor, that was AOBA 9-3.
AOBA, excuse me. Getting confused.
Any other items before we conclude today?
Your Honor, sometimes the Commission reserves exhibit numbers for late filed exhibits. I don't think we have any to propose, but I didn't know if the other parties wanted to have that vehicle available in case we discovered something that should have been proffered to the Commission.
I do believe that staff will be filing an updated comparison chart of the parties' positions, and we would want to use, I guess, the next exhibit number in staff sequence for that.
That would be staff number 18. Okay.
And we would reserve the right to go back and check ours to make sure we don't have any updates to provide, but I don't anticipate any at this point.
Please do. And Mr. Cleaver, you were correct. Exhibit 20 was the correct sequence of your last exhibit. So if you have anything additional, it would be Exhibit 21.
Thank you, Your Honor.
All right. With that being said, briefs are due according to the schedule set forth in the notice, and this hearing is adjourned.
Thank you, Your Honor.